Good morning. Happy Sunday. So, 20 hours ago, I got this particular comment from Expose Evil 5492. He says, "Why did the court dismiss Thompson's charges in Thompson versus Smith, Supreme Court of Virginia, 155 VA 367? Proof an attorney can't understand this case. Watch, everyone." This is the case, Thompson versus Smith, 155 VA 367. And you can see that Thompson appeals a decree entered March 15th, 1929, by the Corporation Court of the City of Lynchburg, dismissing, upon demur, a bill in chancery filed by him against D.C. Smith, Chief of Police of said city, in which he prays that said Chief of Police be enjoined from interfering with his operation of his private passenger automobile on the streets of Lynchburg, and that the Chief of Police be compelled to restore to him his permit to operate a private automobile on said streets, which permit it is alleged the Chief of Police has revoked, acting under the italicized provision of subsection C, blah, blah, blah. And this is an appeal from the decree of the Corporation Court of the City of Lynchburg, Decree for Defendant, Complainant Appeals. The opinion states the case. So this is old-timey language. I don't know what a corporation court is. I assume it's a lower court of some sort. A demur is basically a motion to dismiss on the pleadings, saying that on the pleadings, on the face of the pleadings, the complaint, even if everything alleged is true, the defense still wins. A bill in chancery is essentially a lawsuit in equity. Now, a lawsuit, a suit at law, there were suits in law and suits in equity. There used to be a lot of distinction between them. A lawsuit is where you would sue for money, and a suit in equity would be a suit to get other relief, like injunctive relief. A bill in chancery is a suit in equity. So most courts today, like in California especially, but most courts that I've looked at don't distinguish between suits in equity and suits at law. So you could ask for mixed results. You could ask for money damages and injunctive relief in the same lawsuit. So Thompson was the plaintiff, or here called the complainant. Different name for a plaintiff. And D.C. Smith was the defendant. So Thompson is the plaintiff, right? That's just apparent from this. It's just apparent from the opening paragraphs. So I say there were no charges. Thompson filed a civil action against Smith, the chief of police, saying an ordinance requiring a driver's license revocation, or regarding a driver's license revocation, was void because it delegates powers essentially legislative to an administrative officer. The Virginia Supreme Court agreed and set aside the lower court's dismissal. Sovcits are stupid. So the reason why this case gets cited all the time is there's language in it about the right to drive. Here we go. The right of a citizen to travel upon the public highways and transport property thereon in the ordinary course of life and business is a common right, which he has under his right to enjoy life, liberty, and property, to acquire and possess property, and to pursue happiness and safety, includes the right in doing so to use the ordinary and usual conveyances of the day. None of the existing modes of travel includes the right to drive a horse-drawn carriage or wagon thereon, or to operate an automobile thereon for the usual and ordinary purposes of life and businesses. It's not in your privilege, like the privilege of moving a house in the street, operating a business in the street, or transporting persons or property for hire along the street, which a city may permit or prohibit at will. This is what sovereign citizens always cite as like the takeaway of this case. It is not the takeaway of this case, because it goes on to talk about the exercise of such a common right. A city may, under its police power, regulate in the interest of public safety, but it may not arbitrarily and unreasonably prohibit or restrict it, nor may it permit one to exercise it and refuse permit another of like qualifications under like conditions and circumstances to exercise it. The regulation of the exercise of the right to drive a private automobile on the streets of the city may be accomplished in part by the city granting, refusing, and revoking, under rules of general application, permits to drive an automobile on its streets. But such permits may not be arbitrarily refused or revoked, or permitted to be held by some and refused to others of like qualifications under like circumstances and conditions. So the issue in Thompson versus Smith was he had gotten a bunch of tickets, and this part of the statute, the ordinance, said that the chief of police is authorized and directed to revoke the permit of any driver who, in his opinion, becomes unfit to drive an automobile. So what this does is it allows the chief of police to arbitrarily, there's no guidance for him. He can arbitrarily revoke driver's licenses. And the Virginia Supreme Court said, no, you can't do that. You can't just delegate the power to arbitrarily revoke things, but you can delegate power. There just has to be limitations on it. You can't leave them unfettered discretion. So he responds back, charges were driving while revoked. Charges implies there's a criminal action. Charges implies a criminal action, and you can't get around that. Charges implies a criminal action. Then he goes on to say charge means they charge you money as in tickets. Well, this is Tate versus Lamb. This is another Virginia Supreme Court case. And in Tate versus Lamb, the driver he had two speeding tickets. And the court, this is a 1954 case, the court calls them arrests and alleged convictions because he got the summonses, he paid the bond amount for the speeding tickets. And yeah, they're just speeding tickets, right? He was issued summonses, and then he took his copy. He entered his personal recognizance opposed to cash deposit. So these are misdemeanors. These are misdemeanors in Virginia at that time. So this guy has absolutely no idea what he's talking about because speeding tickets would be charges. Some states still call them misdemeanors. A lot of states like California call them infractions, which are lower than misdemeanors. But a lot of states call them misdemeanors still. So, wrong. Thompson was a plaintiff. He was not the defendant. You say attorneys can't read the case, and you don't even have a basic grasp of the case. Then he goes on to say, the plaintiff, W.L. Thompson, filed a bill for injunction against the defendant, D.C. Smith, Chief of Police of Lynchburg, Virginia. Yeah, that's essentially correct. And then he says, I made a video of your misunderstanding, and I said, cool beans. And so if you go to his page, let's see if we can't find him. So I went looking for it, and dude is, let's just say, dude is a special character. If you want to see crazy, it is this dude. I mean, I'm not saying he doesn't come to the right conclusion sometimes, but he certainly doesn't get there with the he certainly doesn't get there with the right tools. And he believes he's the victim of gang stalking. He has a lot of things in here about gang stalking. So I watched 2 of his videos. It doesn't look like he made a video about me, because this wasn't about me. But let's start off with this one. And this one might sound terrible. Well, I probably won't play it.
Bulls Evil here.
But anyway,
like, share, subscribe.
apparently
Today
in
I'm doing a
2015,
video to show
in
further
2015,
report, right? You type in
he
whoever's
got
name
3
you
tickets.
want, and you can get all this information.
Now, you can see this ticket is from Marcin. Down at the bottom, it says Marcin Nerodzik. And this ticket was entered 5/9/2015. And then, I don't know if was this the same one? Yeah, this is failure. Yeah, so Marcin Nerodzik, 5/9/2015, the Denellen Borough Municipal Court. That's failure to possess driver's license or registration. You'll notice here it says dismissed plea agreement. And he says no plea agreement. Well, I mean, he just wrote that on there. Let's continue on. And here's another one. This one is driving after driver's license, registration suspended, revoked. It's still this Neurodzik guy. It's still 5/9/2015. It's still the same Denellen Borough Municipal Court. And it also shows dismissed with a plea agreement. And then there was a third one, operating or using a vehicle without consent of the owner. Dismissed plea agreement. And it's the same Neurodzik guy. It's hard to see. It's still the Denellen. It's still 5/9/2015. Now, he says there was no plea agreement, but you see that they entered all 3 of these tickets separately. That doesn't mean they dealt with them separately, because they all had the same court date. They were all dismissed on the same date, all the same officer. So what if there was a 4th one? Let me just posit that to you. What if there was a 4th ticket, or even a 5th ticket, or even a 6th ticket? He could have, the guilty plea could have been on one of those, and he doesn't show them to us. He would rather us believe that the court somehow screwed up, got the not guilty initial plea right, but somehow managed to screw up the dismissal due to a plea agreement. I'll let you be the judge of that. I personally think that he pled. So anyway, I didn't see his response video to me, and I'm not going to really spend a lot of time with this guy. I'm probably not going to ever comment again. He says, Maurice, I made a video of you showing how you thought Thompson was a plaintiff. Well, you said Thomas was a plaintiff too. He is a plaintiff. Yes, how does one do that? He petitioned the higher court after he lost. No, he was a defendant, so he filed the higher Virginia Supreme Court. You're right. Those were his other cases with speeding and revoked license. Still, fact is, separation of powers is a big issue today with DMV and DOT. You missed the whole argument in the case. Yeah, Thomas filed an injunction against Smith for violating his right to travel. It's a major constitutional case. It is not. It is literally not. Every case that I can find where this is cited in relation to a right to travel argument, the courts always point to the same thing that every other person points to, and they point to the language that says that that your right may be regulated, that the state may require driver's license to drive. So you're dumb and you're wrong. There are no court cases that infer a right to drive from Thompson versus Smith. There are none. There are none. There are zero judges. There are zero cases where Thompson versus Smith has been successfully used to suggest that you don't need a driver's license to operate an automobile on the public roads and highways. There are none. Every time this case has been brought up, in court, it has been shot down, at least in every recorded case. Maybe somebody convinced a magistrate somewhere that somehow they didn't need a license, but there has been no recording of that ever in any of the published cases. So you're dumb and you're wrong, and seek help. Seek help. Thanks for watching. Have a great day.